Hey everybody, this is Lee Berkstein and I'm here with Cooper. So thanks everyone for joining, and we're going to talk today about a topic that I think is confronting pretty much everyone who owns or operates a small business, and probably larger businesses too, sole proprietors, service providers, which is getting paid. That's obviously an issue always. But more so now than ever, it's an issue for obvious reasons. People have less of an ability to pay. They have some good reasons not to pay. And just from like a long-term business strategy standpoint, there are considerations being given to, how you should approach that. And we're going to really talk about this more from a practical perspective. The idea is going to be to give you some tips about how to deal with these issues in real time, with respect to what's going on now. We'll touch on a few legal issues. I still think, lawyers, even though Cooper has that goatee now or whatever that is. But the focus is really going to be on trying to arm you with some tools to help you take care of these issues yourself.
Great. So before we jump in, just briefly, I'm going to just give you kind of a little bit of background on how the next 30, 40 minutes are going to be structured. We're going to start off with Lee sharing some brief contractual provisions that if you're in one of these situations, the key provisions in the contract that you should be looking to. Then I'm going to be discussing a little bit about how to negotiate, negotiating potential amendments, some thoughts on trying to informally resolve these type of situations, how you should approach that, and some potential pitfalls. We're going to get into briefly a little bit about writing a demand letter, whether that comes from you, whether that comes from an attorney, what the next steps would be in terms of escalation. And finally, we're going to finish off by talking briefly about what the current state of the state and federal court systems are, and how that may impact your strategy as it pertains to these non-payment issues. So with that said, we're gonna go for about 30, maybe 40 minutes. We'll have a little bit of time for questions, and then hopefully be done before 4 o'clock. So I'll turn it over to Lee, who's going to start with some of the contract provisions.
So, the first thing that you're going to want to do if a client comes to you and says, I can't pay, or a client's just not paying and they're non-responsive, is go to the contract. I know we probably repeat that in every webinar that we do, every article that we put out, every video that we put out, but it's really so important. And if you don't have a contract, go to whatever the written understanding is of your agreement, whether that's an email back and forth, a text back and forth. We see it comes in all shapes right now. But go back to the document that kind of memorializes the understanding between you as the business provider and the client, and check to see what the contract says. That's going to be the most important thing if this ever gets to a courtroom, which we're trying to avoid by talking about some of these tips in this webinar. But the second thing is, in terms of leverage, in terms of negotiating with your client, now you want to understand, do you have leverage? Does the client have leverage? And the first thing that many clients are going to come to you with, if they are either asking not to pay or pay a reduced fee or defer payment, they're going to have Googled or seen on TV or watched one of our webinars, and they're going to say force majeure. They might not know what it means. They might know what it means. Force majeure does not apply unless it's in the contract. So you're going to want to go to your contract and see if there is a force majeure clause. I'm going to throw up really quickly what a standard force majeure clause would look like. So it's number 4 here, and the most relevant clause in a force majeure provision is, let's see if I can draw on this for a second, is going to be factors beyond reasonable control, or this is a line, or acts of God, or other activities beyond the party's control. So if there is that clause in your agreement, and the client is pointing to it, hopefully not with this poorly underlined tact, but pointing to it, then it is something for you to consider, and the client might have a little more leverage if, in fact, the force majeure event, in this case, Corona or the government shutdown, makes performance impossible, or they're unable to perform based on that particular event. If there is no force majeure clause and the client says, I'm not paying because of force majeure, one, it might not even make any sense because you're the entity providing the service. But if it does make sense and they're invoking the clause, you can simply respond by saying it's not in the contract. So that's why you should have a good understanding of what your contract says, whether it contains that particular clause, whether it contains any other clause that might speak to excuse for non-performance. And then, you can get into the back and forth about some of the other common law defenses for non-performance, which we've discussed on prior webinars, and maybe we'll get into a little bit later today. So take a look for that. The next clause that you're going to want to be looking at is clauses surrounding non-payment. So the client's either failing to pay or they're not paying. You might have obligations as a service provider with respect to put them on notice of their failure to pay. You have to look in the contract and see is there a notice provision that provides that you have to give them 5 days or 10 days notice before they're in breach of the contract? Do they have an opportunity to cure by making payment at some period after that breach period? So if you jump right to the you're in breach, you haven't paid, but you haven't looked at your contract to see whether or not there's provisions that make for timely notice, then they might not be in breach. And the first thing that a customer who's spoken to an attorney or who has read their contract would respond with is, I'm not in breach. So if you're thinking about how you want to approach this, you really need to understand from a contract perspective how much leverage you have. And we're going to talk about writing demand letters or some type of letter to the non-paying client. You're in the right? If you've provided the services and the client hasn't paid, or you're going to provide services and the client hasn't paid in the proper fashion, then for all, by all accounts, you're probably in the right. So you don't want to shift the narrative to the client is now in the right by misstating things. And the easiest way to misstate is by just not being familiar with what your contract says or what your understanding says and jumping right to the angry letter. So take your time, be methodical, read through the document, make sure you understand what your rights are, what the client's obligations are before you put together a strategy with respect to how you're going to approach the non-paying client. And Cooper's going to talk now about some strategies short of an angry demand letter that you might want to consider when dealing with a client who's failing to pay or asking to pay less.
Yeah. So I guess some of this advice is general advice that it's probably worth thinking about if you run into one of these situations now or really any time in the future of your business. But I mean, truth be told, everyone's hurting right now. There's a lot of fear. There's a lot of, everyone has issues, and there may be legitimate reasons for why people can't pay. And I think it is good advice before immediately sort of threatening legal action or calling your attorney. If there is a way that you can resolve the matter on your own without involving an attorney or without incurring legal fees, we always 100% of the time advise you to do that. It's best to work through these resolutions on your own. If there's a way that you can do that and amicably work together with the person on the other side, that's almost always going to be the best solution. Additionally, if there's a way to safely collect, if let's say you're owed $5,000, if there's a way to get, 70 cents on the dollar and collect, $3,000 of that right now, it's probably worth exploring payment plans, exploring deferred payments, allowing long-term people who you have long-term relationships with to cut them some kind of break and to preserve the relationship and hope that you get paid down the line. The important thing to think about is to ensure that when you are doing that, that those terms are written up. They're written up in an amendment to the contract, and that you're not just sort of openly accepting new terms and potentially amending the contract without fully having everything written down, having everything fully thought through. Now, there are a number of different ways that this could happen. You could, someone owes you, again, like I said, $5,000. You could temporarily agree that for the next 2 months that they're going to pay you $3,500 or that they're going to pay you $4,000. But you want to ensure that the $4,000 does not become the new contractual agreement, that the $1,000 that is not being paid or the $1,500 that is not being paid, that there's some written agreement that basically says down the line that $1,500 must be paid back. That should be in writing. That should be made clear to all parties. There should be a timeline associated with it. And again, you don't need to have a 25-page document. If you write it up, if you memorialize it, that should be good. You should be good to go. The other thing to think about is just general accord and satisfaction. In the event that someone does send you a check and says, the services have already been performed, and someone sends you, they owe you $20,000 and they write you a check and the check is for $10,000 and it says, this is final, this is, in full satisfaction of our contract, and you deposit that, that could be problematic. In the event that you do get a check for $10,000 when you're owed $20,000, you probably should not be depositing it. Even though you may want that $10,000 and need the $10,000 and be owed the $10,000, you want to make sure that you're not doing anything that is potentially going to limit your ability to to recover that full amount. So in the event that you have one of those situations arise, it probably is a good idea to discuss it with your attorney or discuss it with legal counsel. I can tell you want to jump in here, Lee.
Yeah, I just want to jump in with two thoughts, because the first thought is, look, you're going to have to weigh from a business perspective. People are going to be offering lesser amounts of money. The more sophisticated ones are probably going to try the trick that Cooper just used, which is this is in full satisfaction in some way. Things might get worse. People might have less money moving forward. So you're going to have to weigh whether or not it makes sense from a business perspective to just take what's being offered and cut your losses. The second thing is, so much with respect to payment right now is happening electronically, whether it's wire transfer, credit card. You might have put in your invoice, your credit card information, how to pay by credit card, how to pay by wire. It's possible that you get an electronic payment and an email that says, this is in full satisfaction of the money that I owe you. I think the best practice there, if you don't want the money, is contact your bank, cancel the charge, reverse the charge, send the money back, respond with an email that memorializes that you're not accepting it, and reaffirming how much money is actually owed.
Yeah. All right. Jumping forward to the next point, these 2 points go hand in hand, or these two ideas go hand in hand. It is, like we said previously, it is worth fully exploring and seeing if you are able to resolve the dispute on your own. It's also important to make sure that you've fully exhausted your own options before you bring in a lawyer. I think it's always a good idea before the law firm gets involved to send a final letter and make clear that if the dispute is not resolved in X number of days, 10 days, 15 days, if the payment is not made or you haven't received some kind of counter offer to whatever you're putting forward, in X number of days, that then you are going to be bringing in your legal counsel. I think making that point very clear in the event that things do escalate, it's good for when we get involved. It's good for us to know that the individual or the business has fully exhausted its own the remedies that are at its disposal. So it's good to just make very clear to that person, like, don't ignore us. This is the final letter. We are serious about pursuing this. We're not just going to let this slide. Give them a very clear demands, put in writing exactly how much is owed, lay out as many details as you can, make a very clear, lay out the facts and make a very clear ask. Law firms, we do this all the time, but it's very likely that if you do engage a lawyer after that, that there may be an additional letter that's similar, but it is always a good idea for the client, for the business to make that ask on their own and to make sure that they've fully exhausted every potential avenue of resolving it without bringing in legal counsel. We find putting in a number of days is very effective. Also, if you really want to show that you're serious about litigating the matter, you may also want to tell them to preserve all documents, preserve all communications related to the dispute. If they have employees, make sure, just sort of a general like litigation notice, so that they are on notice to not delete documents or have their employees delete text messages or things like that, like a full litigation hold. That may make them realize that you're informed, that you know what you're doing, and that the next step is bringing in lawyers, which most people in this situation want to avoid.
Yeah, I just want to jump in with a couple of thoughts about what we've spoken about so far. One of which, we're mostly talking right now about services contracts. Obviously, sale of goods, there's entirely separate considerations because the UCC applies. And quite frankly, most of our clients are not in the business of selling goods. It's, most of our clients are providing some kind of service, or they're, in real estate. So they're landlords, and the requirements with respect to real estate are a little bit different. And if you're a landlord who hasn't been paid, be it residential or commercial, we've talked about this a little bit in prior webinars, and there are other requirements that you're going to have to pay attention to in order to preserve your rights and make sure that you are laying out your claim correctly. And just other things that might not be applicable to you are applicable to you. I think, in fact, there recently was legislation that you can't charge interest with respect to late payments in the commercial context. I think that came down in the last couple of days. So where there might be an interest clause in your contract that you can use as leverage in your demand letter. So, interest is accruing or a late fee is accruing every month that you miss. You might not be able to do that in the real estate context. So just something to be aware of if you're a landlord or if you're a tenant and you're going to the landlord to ask for free or lesser rent.
All right, Lee, why don't we finish up? There's already a question, but why don't we finish up by talking a little bit about the current state of courts, and in the event that people do need to litigate at this point in time, how that would look. And then we can spend the last couple minutes answering. I see Dan has a question. We can answer that, and then a few other questions if any of them pop up. If you do have questions, throw them up in the Q&A. We are looking at them. And then once Lee's done talking about the courts, we'll start answering a few of them.
Yeah, so I just wanted to kind of segue from it's time to hire a lawyer to what can a lawyer actually do for you at this juncture. And this is the same thing we tell people who are calling us or emailing us. There's not a whole much that a lawyer can do outside of, advocating for you in a non-formal way right now. Cooper talked about writing a demand letter. Look, it probably is for many people a little bit more impressive or a little bit more fear-inducing to receive a letter that has a lawyer's letterhead at the top of it than from you as the business. But one of the reasons why demand letters are so effective in normal times is they are and should be a precursor to litigation. So if they are empty, if they're an empty threat, most people, most businesses can see through that empty threat and disregard the demand letter, because if there's no teeth, then who cares that a lawyer wrote a letter? One of the unfortunate realities of right now is everyone knows that there's no real immediate teeth to a demand letter. Whether it comes from you or a lawyer, It's not going to make a difference. Courts in New York State are not accepting new filings right now. Different in federal. So if there's a dispute between you and your counterpart who's in a different state and there's diversity jurisdiction and it's over the threshold amount of $75,000, or your dispute involves some kind of federal question, you might be able to file in federal court. You might be able to do that right away. And it might go fairly quickly depending on how the judge that it's assigned to is handling new cases. New York State, totally different right now. Paper filings not accepted. Electronic filings are not being accepted. We're being asked the question, when is that going to change? And, I watched the chief judge's video. She posts videos once every few days updating the state of the New York courts. And she says at the beginning of the video that she doesn't know when that's going to change. And I think we have to take that at face value. It's going to depend on public health concerns. It's going to depend on what the governor decides. So, when you're thinking about whether to engage an attorney to write your demand letter or not, and thinking about costs, that's probably another reason why the DIY or do-it-yourself method makes sense, because the typical follow-up that a lawyer would be able to provide you is just not available right now. A savvy thing to include in your demand letter could be, as soon as courts become open for new filings, we're going to be referring this letter to a lawyer to proceed with an action. So you have a window, and that window could be 2 months, or it could be 2 weeks. If things reopen 2 weeks from now, a lawsuit's coming. So take advantage of this window to negotiate with us before we get lawyers involved and before you have to hire a lawyer to take care of things. In the event that you've already filed a lawsuit, you're watching this and you've already filed a lawsuit and you want to get a sense of where things stand in New York State, I just very, very briefly want to talk about where things stand. Just a few days ago, courts have kind of reopened motion practice for pending cases. So that means if there's a case that's already pending, and you were anxious to file a motion to compel discovery or a motion to dismiss, or a motion for summary judgment, you're able to do that again now. And if your lawyer is saying otherwise, you should remind them that that's no longer the case. We have a few pieces of litigation that are in their initial stages where we filed the complaint and we served process and we were waiting for an answer or some kind of responsive pleading when COVID hit. This order does not stop the tolling of the statute of limitations. So the judge the governor basically put on pause the requirements that you answer a complaint in a certain amount of time, whether it's personal service or service by substituted service. That tolling period is not stopped. So, if you filed a complaint, the adversary still has the ability to wait to file an answer until the tolling period is over. So, I think things are certainly ramping up. Going back to motion practice, allowing for motion practice means that things are getting closer to normally resuming, maybe not normally in person resuming, but normally electronically resuming at least. I know there are dozens and dozens of virtual depositions happening every day. Discovery is ongoing. The court system is moving forward. Litigation is moving forward. It's just that new complaints, new issues are not. The one last thing that I'll say on this is because new filings are not taking place yet, there is going to be a major backlog of new litigation. So day one, when the courts say, okay, you can file your complaint now, you can start a new action, there is going to be a flood of litigation never before seen. It therefore further works to your benefit to try to resolve some of these issues, particularly issues that are not, if you're not dealing with a six-figure issue and beyond, if you're dealing with an issue that you think there might be common ground financially, it not only is it going to be expensive, obviously, like any litigation is to litigate, but whereas things were slow before in New York State Supreme Court, particularly the non-commercial division, it's going to be even slower now. It's going to take a very, very long time for your case to get before a judge where things can start to move, because obviously a judge is best positioned to encourage settlement or mediate. So, try to use this time to work things out between the parties to the best of your ability, and remind your adversary or your customer or your client of the fact that this could be a very long process if it can't be worked out in some satisfactory way beforehand. Because quite frankly, there's a lot more going on right now than disputes. Payment is really important. If you were provided services, you should pay for those services. But I think for many people, there is kind of a middle ground, a common path forward for most of these disputes. And, one of the purposes of this webinar and the phone calls that we've been having is to try to encourage people to find common ground with their customers, with their clients, and try to work things out without having to hire us or some other lawyer.
Yeah.
There is just kind of one other issue that we've been hearing about that I wanted to touch on, which is we've been mostly talking about services already provided, real estate contracts, leases, contract of purchase and sale. Also, we've been dealing with disputes in that terrain. We've also been hearing from a lot of people who are service providers, whether they're bands or photographers or they're venues for events. And typically what happens in those contexts are there's a down payment that's provided to the event provider, to the service provider, whether it's the photographer, the band, or the venue. And many of those events are either getting canceled or the client is nervous and it's not going to happen and they're thinking about canceling. And then the argument becomes about the down payment. And Cooper, I know you and I have kind of a little bit of a difference of opinion on this issue. I'm kind of the belief that the down payment is intended to serve as, well, the down payment typically is intended to serve as a deposit for a date, to hold that date. If it's going to be impossible to perform on that date, then in my view, the down payment loses a lot of its power. And if someone's canceling, even for a non-refundable deposit, if they're canceling pursuant to the terms of the contract, but the down payment is non-refundable, some consideration should be given to returning that down payment if it can't be applied to a different date. Cooper, I know you have a different tact on that, a different take on that, but
sorry, I had to emergency plug in my computer. Wasn't okay to the power situation. Sorry.
Yeah.
I think I feel like it's too soon to know how these things are going to play out, but the non-refundable deposit issue, I think, is an open question of how that plays out in the COVID era. Lee and I were discussing earlier. I have some non-refundable deposits for the wedding that I was planning, I don't know. I think my preferred advice and how I'm handling it is to try to preserve the relationship, assuming you're going to continue working with that person. I think you could pick a fight over it. I think it's possible you could get the non-refundable deposit back because the contract is not, you're not able to perform. But if there's a way, I'm taking the advice I give to my clients, which is if there's a way to continue to try to work with that person and preserve the relationship, that is best for the long term. I want to just make one last point, because I think Lee touched on this briefly, but I think with all of these situations, and it actually even gets to Dan's question about whether you should return a check that's marked paid in full. In this time, it is so important you really have to think through where the business that you're dealing with is going to be in 5, 6, 7 months, maybe even longer, maybe even a year. If you are considering potential litigation, it is possible that litigation could drag on for a year, 2 years. And if you're dealing with a restaurant in New York City, it's possible that restaurant could never be back in business, or could be out of business in, could come back and be out of business in a couple months. So you really need to also be thinking through with these disputes. Yes, you're owed money, but maybe getting, 50 cents on the dollar, 60 cents on the dollar, whatever that is from a business right now, as annoying as that is, that might be the best business answer for you. Even though you're entitled to 100% of that money, you really need to think through whether litigating against a business that might be bankrupt in a year or 2 years, when you finally get that judgment, that $1 million judgment, is it worth it? I mean, that is a question that every single business in this situation needs to be thinking about. And whatever, regardless of what side you're on, whether you're the provider or you're receiving the services, we're in uncharted territory, and who knows where things are going to be in a couple months. And thinking through that from a business perspective, I think is vitally important. So Dan, just to your point, I think maybe accepting the check right now might be the best thing you could do. Maybe getting some money in hand and having the dispute be over. In a lot of situations, I would say, take the money, don't worry about legal fees, just wash your hands of this, get the money and move on. But it could also be true that if that person has a ton of money and the person's trying to just stiff you, maybe you don't deposit the check, and you send it back to them and tell them that you're going to move forward with litigation. There's no, every one of these situations is slightly different. But I do think there's never been a time more, this is the time where like a bird in hand is really more valuable than ever.
Yeah, I mean, Dan's question is asking about inter-court insatisfaction. And look, it's going to be somewhat a question of fact. So if you do cash the check, what the client has now done is they've preserved a legal argument to make against you in the event that you decide you want to sue for the balance. So if you want to preserve your right to go after the full amount and leave them with very little in the way of a legal defense, then the smart tactic is to do what you're saying, which is to return the money and send a letter stating that it's been rejected and they still owe the full balance. If you want to straddle that middle ground and you need the money, but you also want to preserve your right to go after the rest of it, even though perhaps they have satisfied the requirements of an accord and satisfaction, you can deposit and send a letter and say, this has been deposited, but there's still a genuine dispute with respect to the remainder of the balance. It's just going to be a decision that you're going to have to make from a business perspective with respect to how badly you need the money and whether you want to actually go after the client or the customer for the balance due. Someone asked about Airbnb type deposits. Vacation rental deposits are really, really tricky right now. Most vacation rental contracts have some kind of cancellation policy. We know from speaking to a number of people that some of the businesses are not honoring that cancellation policy and offering credits in lieu of money returned. That's a situation where you need to have a contract. So if the contract says you're entitled to everything less the down payment or less the deposit, it goes back to what we spoke about before. Are they able to perform? Can you live there? For instance, Cape May was closed to short-term rentals up until a few days ago. I don't know if it still is, but we had a client who was wondering whether or not their Cape May vacation rental was, whether that contract was still binding, and they weren't allowing short-term rentals under 30 days up until a few days ago. So the argument there is, we tried to secure that date with the down payment. We can't now. We can't go there because it's been closed. So it goes back to review the contract and then make a determination as to whether or not the short-term rental provider, whether it's Airbnb or some other rental provider, can actually perform.
Yeah. Airbnb is offering full credits and then partial discount. So you have two options. I know also from personal experience.
Vincent Roldan, who's one of our preferred bankruptcy attorneys, is just raising a good point, not really a question, but a good point with respect to if the customer pays and then goes bankrupt, there's a risk that you as the company get sued for a preference. And his suggestion there, which I don't want to kind of support or not support because I'm not a bankruptcy attorney, but his suggestion is suggest getting funds from a third party or guarantee or getting a lien. So protecting yourself from a lawsuit down the road, but still making sure that you get paid. And it's a good point. And if you have questions about that, you should reach out to Vince to ask Vince about that, and we can get you Vince's information if you do have further questions about that point. So if there are no other questions, Cooper, do you have any final thoughts about non-payment and how you should approach these?
I think the final point is just every situation is so unique. I think we're trying to have a high-level conversation about how best to handle these matters. And I think the issues that we brought up are good things for everyone to consider, but every situation is different. We talk to people all the time who are having these type of issues and disputes, and they're all challenging. They're all different. We're always happy to answer any questions you have, to chat through your issues in an informal way, in a formal way if we need to. But it's tricky, and these issues are challenging, and they're more challenging than ever right now. But just getting ahead of things is important. I think working collaboratively and trying to come up with a solution. If you want to run that solution by us, if you want to, ask us about an amendment that you come up with, whether that's binding, whether it's viable, whether we think it's smart, we're always happy to have that conversation. But think creatively, work collaboratively. However you can get these things resolved, try and do it on your own. But we're always around if you have questions.
I just have one final point, because I don't know if we really brought it up enough, which is if you're a small business and you're seeking to develop a client base or a reputation in the industry, you really also need to give ample consideration to how you approach these situations from a reputational standpoint.
For sure.
This is a time where businesses are defining themselves. Are they money hungry? Do they just want to get paid? Are they looking out for their clients and their community, their colleagues? That might not go very far right now, but if you're a young business that hopes to be around for the next 20, 30 years, that is going to pay dividends at some point. People will remember the businesses that have given them a break, that have tried to work with them, that maybe have deferred payments or worked on some kind of payment schedule with them. And they will also remember the businesses that say, I don't care, you owe 100 cents on the dollar, you owe it tomorrow, or we're not having another conversation. That's not to say that you should let people get away with things if they're trying to take advantage, because there are people using this time as an opportunity to take advantage and not pay for services or for housing or for commercial spaces or for a number of things, even though they have the ability to pay. But there are far more people who just can't, or who want to pay something but can't pay all of it. And I do think that it's really, really important to approach these disputes with as much knowledge as possible, but also with as much empathy as possible, so that you can continue to expand your goodwill and your reputation while you also try to grow your business.
It's a great point. And there's no reason you can't ask for some kind of verification. If someone's saying that they can't afford to pay because they've had a huge dip in their business and you don't believe them, to say, I'm willing to work with you, but you need to, provide me with your last 3 months bank statements and redact whatever sensitive information is in there. I mean, that's what we would do if you brought us in. So I think there's no reason you can't try and come up with creative ways to trust but verify. And But I think Lee's point of being empathetic and really sort of thinking right now about how you want your business to be looked at in the community is really valuable.
All right. Well, if there are further questions, people can definitely shoot us a note. Thanks for joining us on a Friday afternoon, and we look forward to talking in the next few weeks. Thanks, everyone.
Bye.